post. Okay, the postal rule. For me, the postal rule has become a little redundant, or like, frankly, I feel the postal rule has become irrelevant, or it has outlived its usefulness, mainly because today, yeah, people post letters and all that, but letter writing is not what it used to be. So today, emails are more like fast, and they move with the times, because we live in very fast times. Things change in like a split second. People are doing big commercial deals and all that. So whilst letters are still there, today people would communicate their acceptance and their offers in emails, text messages, on phone, and all kinds of things. But you are still required to know the postal rule, because it is very important. They may ask you a question on it. It can be a little tricky. Okay. So the common law adopted the rule, sometimes referred to as the postal rule, that where an acceptance is communicated by letter sent through the post, the acceptance is complete. Please listen. The acceptance is complete and takes effect at the time when the letter of acceptance, properly addressed, is posted. Please, they said when the letter is posted, not when the letter is received, but when the letter is posted, meaning that if I let's just say this is 1980, and I'm selling my car to Deborah, and then I say, Deborah, please, if you want to buy my car, kindly let me know via post, or let me know in the next 3 days. Now, Deborah receives my letter today, the same day. And then she posts the letter on Monday. So Monday is 3 days, so it's within the time. So she posts the letter on Monday. And then I end up receiving the letter a week later. By the postal rule, once Deborah posted the letter on Monday, it's a valid acceptance. So if I don't hear from Deborah, because the letter, I haven't received the letter, so it is Wednesday, I have not received the letter. Thursday, I have not received the letter. And then I decide to sell the item to another person, I'll be found to have breached the contract. Because Deborah had already communicated her acceptance on Monday, and her acceptance is valid on the day she posted it. Yes, the postal rule can be a little crazy, but that's what the rule is. So the rule says that an acceptance, when it is being made by post or is communicated via a letter, is complete, and it will take effect at the time when the letter is posted, and not at the time when you, as the offeror, receives the letter, but at the time when the letter is posted. So similarly, an acceptance by telegram, okay, they don't mean today's telegram, not the app Telegram. Back in the day, they used to have a postal system, or a communication system known as telegram, okay? So they hand over whatever message it is, and then it will be transmitted to you. And using that telegram system, they said that acceptance by telegram will take effect when the telegram is handed in for transmission to the addressee, okay? When it's handed in for transmission to the addressee. So when I give it to the communications person I meet at the place, the person who transmits it, then is deemed to have been what? Accepted on that date. So where an acceptance is communicated by post, when does it become legally effective? We've mentioned it. The court had to choose between a number of possibilities. When the letter of acceptance is actually received by the offeror, when it should, under normal circumstances, have been received, or when it is posted. And the courts have resorted to go with when it is posted. Okay, when it is posted. So we'll look at other principles relating to the postal rule. 1, for the postal rule to apply, the rule of acceptance must have been, the letter of acceptance must have been posted. And for this purpose, a letter is deemed to have been posted when it is in the control of the post office. That's 1. 2, Generally, the postal rule only applies when it is reasonable to use post as a means of communicating acceptance. So here is where you can wiggle your way around, especially in today's modern era. So I made you an offer on Instagram or WhatsApp, and then you decided to communicate your acceptance to me in a letter. That's absolutely stupid. So in that case, the postal rule would not apply, because we are told here that the postal rule would only apply when it is reasonable to use post as a means of communicating acceptance. And if I made you the offer on Instagram or WhatsApp or Telegram or Facebook, then you need to communicate your acceptance on Facebook and not by a letter. So if you post me a letter and I don't receive, I can go to court and tell the court that, look, I made this person the offer on Instagram. It's an instant messaging site. So if she wanted to buy the thing, she could have instantly accepted it on that messaging site. Okay. 3, the postal rule applies even if the letter of acceptance, this is the part that is that just beats my imagination. When I was in law school, I didn't understand it. To date, I still don't understand it. The postal rule applies even if the letter of acceptance is delayed or wholly lost in the post and never reaches the offeror. Can you imagine that? You are selling something to somebody. You've communicated to the person in a letter. You don't hear anything from them. Then the law is telling you that even if the person posts it and you don't receive it, that acceptance is valid. It makes absolutely no sense. But that is what the law is saying. That the postal rule will still apply even if the letter is delayed, the letter gets missing, and never gets to you. It is still a valid acceptance. Please take note. They are saying that the postal rule will still apply even if the letter is delayed, the letter gets lost, and is never brought to your attention as an offeror. That acceptance that the person made is still valid. Okay. Then also, the 4th one is that the postal rule can be excluded by the terms of the offer. Okay, you can exclude the postal rule. You see, because the postal rule is a little crazy, this principle allows you to exclude post as a means of acceptance. Okay, you can exclude post as a means of acceptance. So you can say that, look, yeah, if you want to buy my item, you have to communicate to me, phone call, WhatsApp, Telegram, this, that. Or you can still use a letter and say that this acceptance would only be valid when it is received. Okay, when it is received by me. But this one, you have to make it express in your offer. But if you don't make it express in your offer, that the letter would only be, the acceptance would only be validly communicated if you receive it as the offeror. If you want that, you have to state expressly. But if you don't state it as express as it comes, then the postal rule will apply. And the postal rule says that the acceptance is valid when it is posted to you. So it doesn't matter whether you receive it or not, or it is missing. Once it has been posted, it is valid. If you don't want it to be the case, then you have to expressly state in your offer that acceptance would only be valid when it is received by you or when it is communicated by another means. Please, I hope you understand me. Okay. So now we'll look at the difference between acceptance and counter offers. I've already mentioned them before. When we started our discussion on acceptance, I mentioned to you certain keywords. I said unconditional. I said unqualified. I said there's another word I used. Forgotten, but I used those 3 words, okay, to show that an acceptance must be, you must, when you're communicating acceptance, you receive the proposal made in the offer the same way you received it. Okay. So whoever is making you the offer, the terms they came with is the same thing you are accepting. You don't change anything around it. You don't modify it. You don't add anything. You don't qualify it. You don't conditionalize it. You don't do anything. You accept it the way it is presented to you. Now, when you decide not to accept it the way it is presented to you, and you decide to modify or amend the offer, then it is no longer an acceptance. That thing is not an acceptance. It is a counter offer. So it means you, as the offeree, now becomes another offeror, sort of, because you are making a counter offer to the person who initially made you the offer. So in order to qualify as an acceptance, the response of the offeree must be a final and unqualified assent to the terms proposed in the offer. To conclude a contract, the offeree's response must be an absolute and definite acceptance of the terms proposed in the offer and must leave no room for doubt. Thus, a reply or response to an offer which varies the terms of the offer or introduces terms different from those indicated in the offer amounts in law to a counter offer and not an acceptance. So if you come like Deborah or Priscilla and you say that, look, madam, I know that you are selling your car for 50,000, but I don't want to buy it for 50,000. I want to buy it, but I'll buy it for 25,000. It means that Deborah is making me a counter offer. Okay. So what is the effect of a counter offer? A counter offer communicates a rejection of the original offer. And let's go back. Let's tune our minds back to what we discussed when we looked at termination of offers. You remember that under termination of offers, one of the ways to terminate an offer is by a counter offer. Okay, so a counter offer would amount to a rejection of the original offer, and then would be you as the offeree making a new offer to the offeror or the one who initially made you the offer. So Deborah says, madam, I'm not buying your car for 25,000. The minute she, for 50,000, the minute she says, I'm not buying your car for 50,000, but I'm buying it for 25,000, it means she has rejected my offer to buy the car for 50,000 and is rather making me a new offer to sell her the car for 25,000. Please, I hope you get me. Secondly, a counter offer operates to nullify or destroy the original offer such that it cannot be subsequently accepted. A counter offer, it operates to nullify or destroy the original offer. So if Deborah comes to me and says, madam, I'm not buying your car for 50,000, but I'm buying it for 25,000, it means that she has destroyed or nullified the offer I made her. Meaning that that offer is no longer available. It's gone. So if she says, madam, I'll pay 25,000, and I say no, and then she comes back to me 2 days later and says, madam, look, I know you say you won't buy the car for 25,000, so I'll pay the 50,000. And then I tell her, Deborah, please, I've sold the car to Priscilla because Priscilla says she will buy it for 50,000. Deborah can't sue me because the minute she made me a counter offer, it nullified the original offer. So meaning that she cannot come and accept the original offer that I made to her. Okay, she cannot come and accept the original offer that I made to her. So if I sell it to some other person, she cannot sue me in court. Okay. So finally, we'll look at silence as a means of communication. Silence as a means of communication. Silence as a means of communication. So can silence amount to a means of communication? Okay. Or can silence be a mode of acceptance? So that if I communicate to Noah that Noah, do you want to buy my car for 50,000? Or I'm selling my car for 50,000 and I don't hear anything from Noah, then I'll say that, oh, Noah has bought the car. Is that it? That's the question that this point seeks to raise. So as a general rule, an offeror is not allowed to arbitrarily impose contractual liability on an offeror by stipulating that his silence will be construed as acceptance. So What this point is saying is that I cannot say as an offeror that in my offer that if I'm selling my car for 50,000, if I do not hear from you within 2 days, I would take it that you have bought my car for 50,000 or you have accepted to buy my car for 50,000. No, as a general offer, you cannot do that. As a general rule, you cannot do that. You as an offeror, you cannot impose on your prospective offeree silence as a means of acceptance. Okay, so that's an offeree who does nothing upon receiving an offer which prescribes silence as a mode of acceptance is not bound by the contract. So if I write or I indicate to Deborah or anybody, any other person I'm selling the car to, that I'm selling my car for 50,000. If I do not hear from you within a week, I would consider that you've accepted to buy my car at so and so amount, at the 50,000. And then after a week, I don't hear from Deborah. I cannot go to court and tell the court that, look, I told Deborah that if after 1 week I do not hear from her, then I would deem that she has accepted my offer. No, I cannot do that. I cannot go to court and say it was an acceptance. No, the court won't see it as an acceptance. Okay, the court requires you to equivocally or clearly, the court needs the offeree to clearly communicate their acceptance. So silence cannot be a prescribed mode of acceptance, such that if the party opts to be silent, and then you now force them to buy the thing. No, you cannot do that. Silence cannot be forced on anybody as a mode of acceptance. Okay, so we are done with our discussion on offers and acceptance. So we'll take a 9-minute break, and then when we come back, we'll start with our discussion on consideration. Okay, we'll start with our discussion on consideration. If you have any questions, just keep them. When we come back, we'll look at them. Okay. Okay, welcome back. Please, I hope you stretched it a bit. And I hope you also thought about some of the things we had talked about, such that if you have any questions, you would put them together. And then when we are done, we can look at them. Okay? Okay. So we have looked at offer, we've looked at acceptance. So now we would turn our attention to consideration. Okay. So consideration, simply put, consideration, simply put. Now we are looking at the promises. Okay, we are looking at the promises. We've looked at you making the offer. Okay, you making the offer and you making an acceptance. Now we are going into the offer and acceptance to see what exactly you are offering and what exactly anybody is accepting, what the other party is accepting. This is where the conversation around consideration sits. Okay, so consideration is an act or forbearance on a party or a promise thereof. Okay, it is the price for which the promise of the other is bought, and the promise that is given for value is enforceable. The promise that is given is enforceable. Okay, so you'd realize that the promise, it could be me selling my car. So the consideration that what I'll be putting up there, the offer would be the car, and then the acceptance that will be the amount I want to pay for it, the amount one of you wants to pay for it, either Deborah or whoever is going to pay for it. So that 50,000, would be the consideration. Okay, the consideration for the offer that has been made. In the same vein, sometimes the consideration would not be tangible. Okay, would not be tangible. That's where it is an act, something asking you to do something or asking you to forbear. That is not to do something or lose something. Okay, so in the case when we look at unilateral contracts, for example, we realize that I'm saying that if you do this, I'll pay you. So sometimes you going to catch the criminal to bring to me, that would be the consideration. Or you looking for the book for me, then bringing the book to me, that is the consideration. Okay, so the general rule is that any simple contract that is not supported by consideration is unenforceable. Why is it that when a contract is not supported by consideration, it's not enforceable? Because once it is not supported by consideration, it makes the arrangement gratuitous. When I say gratuitous, it becomes free. So if I'm making you, if we are in a free arrangement, why should you be able to sue me? So I'm giving you my car for free. You're not paying for it. So if I change my mind, why should you be able to sue me? Do you understand? So that's why the general rule is saying that any simple contract that is not supported by consideration is unenforceable, because the consideration is what you are losing, for which reason I should act. Okay. So if you are giving me 50,000, yes, it's 50,000 I want. So you are giving me that, and then I'm giving you my car. But the minute I say, oh, I'm giving you the car, you can take it for free. Why should it be enforceable against me? It's free. You're not doing anything for it. You're not giving anything for it. So if I change my mind, big deal. You understand? So this means the absence of consideration renders a contract invalid. So for a contract to be valid, there must always be consideration. So Section 10 of the Contract Act provides that a promise is not invalid as a contract by reason only that the consideration for the promisee is supplied by a person other than the promisee. Okay, so please, let me just correct it now. Promisee, okay. So a promise is not invalid, okay. It would not be invalid. So consideration will still be consideration, even if the consideration is coming from another person other than the promisee. So I'm selling my car to Deborah. But Deborah is not the one who is going to pay me. It's Deborah's dad that is going to pay me. It doesn't mean that the consideration is not valid. It's valid because I'll still receive the consideration, just that it's not coming from Deborah. That's all the point is trying to say. Okay. So now let's look at types of consideration. We have executory consideration, executed consideration, and past consideration. Okay. So consideration is said to be executory when it consists of a promise to be performed in the future, which is given in return for a counter promise. So this is the one that we know. This is the common one that we know about. So I make one promise, you make another promise. So the promise is I'm going to sell you my car if you pay me 50,000. So my car is one. The 50,000 that you are giving to me is another. So exchange of promises, so counter promises. Okay, so this kind of consideration arises from bilateral contracts, where the contract is formed by the mutual exchange of promises. A good example of which is a contract for the sale of goods to be performed in the future. Now, an executed consideration, on the other hand, is where the contract consists of an act which is performed in exchange for a promise. So you realize that when we discussed unilateral contract, that was it. One person promises to do something when another person performs an act. So here it is an exchange of a promise for you doing something. Okay, you perform, I'll promise you something when you perform. Okay, so executed consideration arises in unilateral contracts, which are typically formed by the exchange of a promise for the actual performance of an act, such as reward contracts. The performance of the act constitutes the acceptance as well as the consideration. So this is simple to understand. Once you understand what a bilateral contract is, it should be easy for you to understand executory consideration. When you understand what executed a unilateral consideration, unilateral contract is, then it's also easy for you to understand executed consideration. Now we are going to past consideration. It's a little tricky, but it is simple. All it is saying is that consideration is said to be past where the act constituting the consideration is wholly done or the detriment wholly suffered before the promise is made. So here, before I explain it, let me give you this scenario. I come to one of you's house and then I start mowing your lawn, or I start gardening or doing something in your house. Then when I'm done with it, then you come and tell me, oh, madam, I'll give you 2,000 for this thing you have done for me. That is said to be past consideration, because you realize that at the time that I was doing the act, there was no consideration. So whatever it is I am doing, I have already done. Okay, whatever it is I'm doing, I've already done. Whatever detriment I will suffer, I have already suffered it before the promise is made to give me money or to give me something. So the consideration only comes after I have done the act. Okay, so that's past consideration. So the consideration is past if the promise comes after the act has been fully performed without any reference to the promise, which is made later. So when I was mowing the lawn, I wasn't mowing the lawn with the intention that I would be given money. I mowed the lawn on my own. And then after I had mowed the lawn, you told me that, oh, madam, I'll give you money for it. The promise is subsequent to and independent of the act. Okay, so the promise happens after the act has happened, and the promise is separate from the act. So I've done the act already. So it's separate from the promise. The promise comes after it. and therefore the promise and the act do not constitute one and the same transaction. Okay, so I came to mow the lawn. At the time, nobody has told me they are giving me money. After I had done it, and then I was told, oh, I would pay you. Okay, so at the time I was doing it, I had no idea I was going to be paid. That is one. So the mowing of the lawn and the promise to give me the money are two separate things. And they do not arise out of the same transaction, except to say that I was promised to be given the thing after I had done the thing. So that the promise is not deemed to have been given in exchange for the act. Okay, the promise is not said to have been given in exchange for the act, but rather constitutes a promise of a gift subsequent to the act. So when I was doing the thing, nobody had promised me anything. So the promise that was made to give me the money is not in exchange for the act, but rather it constitutes a promise of the gift after the act has been done. So that is past consideration. So an example is if A makes a present of a car to B, and a year later, B promises to pay for it, there is no consideration for B's promise to pay. You understand? A makes a present of a car to B. So let's take it that I'm A. I make a promise to Deborah to give her a car. And a year later, Deborah promises to pay for it. At the time I was promising to give Deborah the car, she hadn't told me she was going to give me money. And I had decided on my own free will to give her the car. So if a year later, Deborah says that, oh, madam, I want to give you money for this car, the money that she is deciding to give me is not consideration for the car. You understand? The consideration, that is the act of giving the car, is past in the sense that it has wholly been done before the promise to give me money was made. The promise is subsequent to and independent of the act, which is alleged to constitute the consideration. So there's a case here, Roscola versus Thomas. So in that case, the defendant sold the horse to the plaintiff. After the sale, the plaintiff asked the defendant if the horse was sound. So listen, you sold the horse to the plaintiff. Now, after the horse had been sold to the plaintiff, the defendant asked if the horse was sound. The defendant responded that the horse was sound. The horse turned out to be unsound, and the plaintiff brought an action for breach of warranty. It was held that the sale itself created no implied warranty that the horse was sound, because you realize that at the time the sale was being made, right, the buyer hadn't said anything, hadn't asked about the soundness of the horse. And the person who was selling the horse to hadn't made any representation about the soundness of the horse. So he was just selling his horse. And then after he had sold it, you asked him if the horse was sound. So initially when you were buying the horse, its soundness was not part of the discussion. It wasn't part of the consideration. Okay. So now you finding out that the horse was unsound after, well, it's neither here nor there. It's past and gone. So the warranty had to be regarded as independent of and subsequent to the contract of sale itself, because I'd already sold you the horse before you asked me whether the horse was sound. So at the time you were buying the horse, you were not buying it with its soundness. You were just buying a horse. So subsequently, it turned out that the horse was unsound. But no, it doesn't matter, because it wasn't part of the consideration when you were buying the horse. So since the warranty was based upon the previous transaction, it constituted past consideration. Okay. Another example of past consideration, this one will make you understand it very well, is the case of Eastwood and Kenyon. So in the case, the plaintiff, Eastwood, had been a guardian and an agent of Mrs. Kenyon while she was a minor, okay, while she was a child. And this Eastwood went ahead to incur expenses to voluntarily incur expenses and improve Mrs. Kenyon's property. So when Mrs. Kenyon grew up or she became of age, she promised to pay the money that Eastwood had borrowed for the improvement of her property. So you see, at the time when Eastwood was doing those things, she hadn't asked him to do anything. She didn't say, oh, do it and I'll pay. Eastwood did them, and then later on, she said she will pay. Okay. So the court held, so now Eastwood, she hadn't paid, Mrs. Kenyon hadn't paid. And then Eastwood sued her for the amount that she promised she will pay. The court held that the moral obligation of Mrs. Kenyon to fulfill the promise was not sufficient consideration since the act that they were purporting that she was paying the consideration for had already been done before she gave the promise to pay. So the consideration was passed and the promise was therefore unenforceable. At the time when you had incurred the expenses, she didn't tell you that incur expenses and I'll pay. You incur the expenses. And then later on, she said, oh, because you are my guardian and you incur those expenses, I feel bad, so I'll pay for them. But you had already done them. Okay, you had already done them before she decided that I will pay. Okay, so if now she didn't pay and you sued her, the court said, no, it's past consideration. You had already done them. Okay, you had already done them. So in this case, it is unenforceable. However, there are exceptions to this rule. There are exceptions to the past consideration rule. The general rule when it comes to past consideration is that the general rule is that once consideration is after the fact, okay, comes later on, after an act has been wholly done, right? It is not binding. So I'm not under any obligation to settle past consideration. It's not valid. Okay, there's no obligation on me to settle something you had already done. You've already done it. So the consideration is past and gone. Okay, so no court can force me to pay you the money for something you had already done without knowledge that you were going to be paid. It's later that I told you I'll pay you. So if I decide not to pay you, nobody can do anything to me. However, there are exceptions to the rule. Okay, there are exceptions to the rule. So now let's look at the exceptions. Once we are done with this rule, we'll close and then continue on Thursday. A, act specifically requested by the promisor. An act specifically requested by the promisor. So if the promisor requested you to do something, okay, if the promisor requested you to do something, then it would amount to valid consideration. So past consideration will be sufficient to support a subsequent promise if the prior act or service was done or rendered at the express request of the promisor. So, you know, we've said that past consideration is not binding, is not valid. Usually it is because you did the thing. I didn't ask you to do it. You did it all on your own. And then later I said, I'll pay you. So if I decide not to pay you again, it's subsequent to what you had already done. So it's not an issue. But they are saying here that an exception is that if that thing that you did, the previous thing that you did for the thing that you did before. So let's just take it. When I said I come to one of your homes and I decide to mow the lawn. Let's just say when I came to your house, you told me to mow the lawn. So I went to Deborah's house and Deborah says, oh, madam, can you mow the lawn for me? And then I mowed the lawn. And then after Deborah said she will pay me money and she didn't pay, I can sue Deborah for the money because me, I was sitting my somewhere and then she told me to mow the lawn. Even though she had not promised to give me any money, she told me to mow the lawn. And it's different from where I decided to mow the lawn on my own volition. Please, I hope you understand what I'm saying. Please, I hope you understand what I'm saying.
Yes, yes.
Okay. So if she's the one saying, madam, please mow my lawn, and then I mow the lawn for her. And then later on, after mowing the lawn, she said, oh, madam, I'll pay you 2,000 for you mowing my lawn. And then she decides not to pay me. I can go to court and sue her for not giving me the consideration. And then the court would actually side with me and give me the money. Because in that case, even though it's past consideration, it's an exception to the rule because she requested me to do that thing for her. Okay. So in the case of Lampe and Braithwaite, the defendant killed a man and had been convicted of murder. He asked the plaintiff, so this defendant who had killed somebody asked the plaintiff to do all he could to obtain a pardon from the king for him. The plaintiff exerted himself to this end, journeying, going to and from London at his own expense, and was able to obtain a pardon for the defendant. Later, the defendant promised to pay the plaintiff £100 for his trouble. So you see that in this case, you've killed somebody. Then you go to this plaintiff and tell him that, oh, I beg you, can you get the king to pardon me for this thing that I have done? But you didn't promise to give him money. So you didn't promise to give the plaintiff the plaintiff any money, just that you went to beg him to go and get a pardon for you. Now this plaintiff goes to exert himself, goes to see what he can do, organizes people, lobbies people, and they go and beg the king and they get a pardon for you. Now, after they got the pardon, then you promised him that, oh, I'll give you £100 for your trouble. And then the defendant decided that he won't pay. He didn't pay. The court held that even though the alleged consideration was wholly given, that is, it is past, it was wholly given before the promise of remuneration or the promise to be paid money was made, the promise was enforceable because the act constituting the consideration was done at the request of the defendant. So it is the defendant that had requested the plaintiff to do it. So even though he had done the act before he was promised the money, because he did it at the express request of the defendant, it means the promise made is what? Enforceable. The consideration is enforceable. Okay. Another exception, an act done by way of business. That's another exception to the past consideration rule. So the past consideration rule is that past consideration is unenforceable. However, it can be enforceable first and foremost when the act is specifically requested by the promisor, and then two, where the act is done by way of business. So an act done before giving of a promise will constitute consideration if the act was done by way of business and the parties understood at the time of performance that the act was to be remunerated or paid for, and the payment, if promised in advance, done, or the services are rendered by way of business and not as an act of friendship. Here, it is presumed that both parties must have understood that the act would ultimately be paid for. In this case, the subsequent promise is treated as an admission of the bargain and serves to fix the amount of remuneration to be paid. So you see, sometimes, I mean, this happens, this is the case, or this talks about commercial transactions, okay? Commercial transactions. So let's take it that you are a bank. So Cal Bank, right, arranges food for its staff. So Cal Bank contracts with somebody. So Cal Bank put in a call to, let me say, Golden Tulip, and said that every afternoon, Golden Tulip should cater to its staff, bring food. They didn't talk about money, right? They just said, oh, Golden Tulip, this is CFO Cal Bank. We want you to bring us food. And they told Golden Tulip that it's Cal Bank. Now, maybe they didn't sign an agreement, like an agreement. But the thing is that if it's not a commercial transaction, what business would it be for Cal Bank to call Golden Tulip to come and give its staff food? Cal Bank is a bank. Golden Tulip is in the business of cooking food. So why would Golden Tulip just out of the goodness of its heart cook free food for Cal Bank? You understand? So even though they may not have agreed to payment or remuneration, it is seen as a commercial arrangement because Golden Tulip is an entity on its own. that is in the business of cooking. Cow Bank is an entity on its own in the business of banking. So in what world would Cow Bank and Golden Tulip contract for free? So it is assumed that such a contract is being done by way of business, so that even if they didn't agree on money, and then Golden Tulip on Monday morning or Monday afternoon delivers 10 packs of jollof rice to Cow Bank head office, and then Cow Bank says that, oh, we pay 1,000 cedis. Then later they change their mind and they be like, won't pay again. Why won't they pay? Because it is past consideration. The court would never agree with Cow Bank, because for the court, it is a business transaction. And if you look at it, it's not a friendship, it's a business transaction. So it is meant to be treated in that vein. So even though the parties may not have agreed to any amount, the intention that is meant to be business is always there. Because obviously, Cow Bank won't call Golden Tulip to come and give them food for free. So even though they've not agreed on the amount and they've not discussed money, and Cow Bank only agrees to pay later, because it is a business arrangement, no matter what, Cow Bank would have still paid for it. So that's an exception to the past consideration rule. So let's look at this case. There's a case that exemplifies what I'm trying to explain. So we have the case of Reed Casey's patent, Stewart and Casey. So in that case, A and B were joint owners of a certain patent right, and they wrote to C that in consideration of his services as the practical manager in working on their patent, they agreed to give him 1/3 share of the patents. A and B subsequently refused to fulfill this promise, arguing that the promise was made only in return for C's past services as manager. So please, I hope you understand what this is saying. So this A and B, they are co-owners of patent rights. Now, this C person was working with them as a manager. He had been working with them all this while. Now, later, they told him that, oh, for all the services he had done in the past, right, they were going to give him 1/3 share of their patent. So they were going to divide their patent rights into 3 and give him one of it. Then they said, oh, they changed their mind. They decided not to give it to him again. And then he sued them. Now, when he sued them and then they went to court, they were like, oh, but he had already done those things. He was already the manager. He had already done those things before they decided to give him the thing. So it is past consideration. It's past. So it is not enforceable. The court held that the nature of the past services that C had rendered raised an implication that the services would be paid for. The services that he had rendered them, because it's a business transaction, it would be paid for. So the subsequent promise to pay was therefore simply an admission of the bargain and served to fix the amount of the remuneration that had to be paid. Because for them, they are like, obviously, it's a business transaction. It cannot be free. So there's always the thought that it is supposed to be paid for. So even though it was a subsequent promise to pay, it was merely an admission that, look, this is us. We are now bargaining on how much we'll pay you for all the services that you had rendered to us. Okay, so in that case, it was held that the consideration was enforceable, even though it was passed. Okay, even though it was passed. I see there's a few comments. Let me just go back and look at the comment, and then we'll proceed from there. 3 new messages. Okay. So Sichu has 3 questions. Let me take them one after the other. His first question says, in a case where a seller and a buyer agree on the sale of a car, but the consideration came from the parent of the buyer on behalf of the buyer, what is the legal relationship between the 3 entities? Does the parent now become the buyer? No, the parent doesn't become the buyer. The buyer is still the child, because on the face of the contract, his name is there. So let me complicate this for you again a little. You go to You go and collect a loan to buy a car. And you know, there's some arrangements like that. When you go and you are buying the car, you don't pay for it yourself. So it's not like the bank would release the funds or disburse the funds to you directly to go and buy the car. The bank will pay the dealer directly. When the bank pays the dealer directly, does the bank now become the buyer? No. Okay, no. Rather, the buyer is still the buyer and the seller is still the seller. If the seller is CFAO, they are the seller. The buyer is, let's just take it, I'm the one. I went for a loan from Cal Bank to go and buy a car. Now, Cal Bank didn't disburse the funds directly to me, but it disbursed the funds directly to CFAO. CFAO is the seller. Me, I'm the buyer. You understand? So in our arrangement, the relationship that we have, I am the buyer, CFAO is the seller. As between me and Cal Bank, there's another contract. There's another contract. The contract of borrower and creditor. I'm the borrower. I went to borrow money from Cal Bank to buy a car. So I also owe Cal Bank and I'll pay for it. So that's a separate arrangement. The fact that the buyer paid, the bank paid for the car on my behalf doesn't make them the buyer. Okay? Unless, of course, in the purchase, because they paid, sometimes it happens, banks do it. They'll register the car in the names of both me and the bank. That's different. But if I'm the one buying and I came for a loan to go and buy, even though the bank will directly give the money to CFAO, the car is mine. Okay? But there's a contract between me and Cal Bank for me to return the money to them. So if I don't return the money, they can go and sue me in court. Okay? In the same vein, if I'm a parent and you, Sicho, for example, you are my son, and you've seen a car at CFAO that you want to buy, and can tell me, oh man, I want you to buy me the car. Yes, I can be the one to go and buy the car for you and pay for the consideration to the CFAO people. But at the end of the day, who approached CFAO? You did. So you would be the one entering into the contract with CFAO. Okay? So you will be the recognized buyer. But, and it's interesting that you raised this question too, because you see, when we come to intention to create legal relations, you realize that some types of relationships don't evoke contracts, okay? So the relationship between parent and child, it's not seen as a contract per se. So that if you, my son, you, Sicho, you are my son, and I'm buying you a car, it will not be like between me and you and the bank, or me and the bank. Okay, because it will be deemed like, oh, your mom is paying for the car for you. So it's a free money, it's like free money. Your mother is buying you the car for free. Okay. Unless, of course, your mother says, I'm buying you the car and I expect you to pay me back. But ultimately, who CFAO will recognize in their books is you and not me, because you approached them to buy the car. The only thing is that I'm the one paying for the car. Unless, of course, you, Sicho, decide that, oh, man, because you are the one paying for the car, let me register the car in your name, or let me go and sign the contract on your own. But once you are the one buying the car, you are the seller, you are the buyer, and then the seller is CFAO, just that it's your mother that's funding it. Okay, that's the first question. The second question says, don't know why this is. So under the exceptions of past consideration, upon the express request of a promisor for a promise, can it hold if the promisee is not of legal age, taking the situation of the relationship between a minor and the legal guardian? Yes, it will hold. You know why? Even if the child tells you that I'll pay you, okay, I'll pay you. You know, for children, when we come to intention to create, so I know these questions are taking us a little step further. But as in, when it comes to contracts with children, right? Unless whatever the child is buying is a necessary, it's something that is necessary for them, for their livelihood, right? The contract cannot be enforced against the child. That's the general principle. Okay, that's the general principle. However, if whilst the person was a child, right, you did all those things for the child, and then when they became of majority, that is when they grew up, they told you that for all those things you did for me as a child, I will pay you. Okay. And they decide not to pay you. Like in the case of Mrs. Kenyon, it is right. But let's just take it that the child promises. So as we are buying things on their behalf, they promise you that, oh, no, so it's the child who requests you to buy those things on their behalf. So the child says, oh, buy me this, buy me this, buy me this. And then you went ahead and bought that child all those things. And then once they grew up, they promise that they will pay you. And you go to court. And the issue comes as to, does it amount to past consideration or it meets the exceptions? This is how I think the court should treat it. For all the things that were necessaries of life for that child, so the child needed those things. For necessaries include things like things that the child needs to grow. Okay, things that the child needs to grow. So a proper, like a basic education, food, shelter, etc. Right? The child asks you to buy all those for those things, because those things are things that the can be enforced against the child, even when they are children. I think the court is likely to say, yes, because that child asked you to buy them those things when they were young, okay, when they were young, yes, indeed, then it amounts to sufficient, it amounts to good consideration, okay, or it's enforceable consideration. But for those other things that were not necessaries of life, well, you bought it at your own peril because it's a child. Technically, a child cannot even enter into a contract with you except for necessaries of life. Okay, the necessaries of life. So those other things that are not necessaries of life, even if the child asks you to buy it for them, I doubt a court would be able to tell you that it amounts to valid consideration. Okay, I don't think a court would hold that it amounts to valid consideration. So that's my take on it. But all these things, these questions would make a lot of sense when we treat intention to create legal relations. So when we get there, Sitope, you can remind me to take this point once again, okay? Because for children, when you contract with children, the contract would only be enforced where you are contracting with them for necessaries of life. And also, this whole conversation around children and contract would not apply if you are the child's parent. If you have a child and you are taking care of your child, I don't see why you later sue your child to pay you, even if your child said, Ma, I'll pay you for all the things, or Ma, go and buy me this, Ma, buy me this. It's your child. It's your responsibility to take care of that child. Okay. So for those ones, I don't think you'll be able to claim anything because that child is yours. But if it's another person who is maybe suddenly stands in loco parentis or becomes a parent of that child for some reason, not that they are their biological parent or they are their biological guardian or anything like that, but because maybe that child went to learn a trade or they owned a shop and the child came and said, I'm buying this and buying that and buying this, and then or give me this and give me this and give me that. And then he gave those things to the child. And then the child later said, I'll pay you. Well, that's a different conversation from the type that is like, oh, I'm your mother, I'm your father. Because if you are a mother, father, those things, they are required of you. Okay. So consideration issues don't really come in here. Okay. Consideration issues don't really come in here. Especially when the person is your child. When the person is your child. Okay. And then the last question is, will cow banks still be liable should they refuse the food offered by Golden Tulip? Will cow bank be liable should they refuse the food offered by Golden Tulip? Yes, they would be liable. They would be liable in the sense that that's the question I kept asking. Cow Bank and Golden Tulip, why would they enter into any arrangement? You remember that we discussed something around contracts by conduct, right? You are Cow Bank. I am Golden Tulip. I'm a business venture. You are a business venture. We are dealing at arm's length. Why would you all have your CFO place a call to us and say you are ordering 10 packs of some food for your business people? Even if we didn't agree on the price, you still made a request for the food. You understand? So unless Cow Bank's defense is that we didn't order the food, we didn't ask our CFO to order the food, that's a different conversation. But if Cow Bank admits that it actually ordered the food, then they'll be liable to pay for it and they can't turn Golden Tulip away. You understand? In contract, there's something called quantum merit, but that's even when it comes to contract of services or contract for services, for example. So that if we agree that I'll come and mow your lawn and I come and mow the lawn a bit, even if we've not agreed on money or agreed on something, you should be able to give me some amount of money. So this is a similar thing. Why would you call Golden Tulip as Cow Bank and say we are ordering food? Unless it's a prank. If it's a prank, that's a different thing. So then their defense would be that, oh, we didn't ask anybody to order food on our behalf. But if Cow Bank admits that they did ask Golden Tulip to cook food for them, then they'll be liable. I hope you understand what I'm saying. If the issue comes up and they said, oh no, we didn't ask anybody. There's no in-house instruction that our CFO or our HR manager or our procurement manager should contact Golden Tulip and order food for the staff. That's different. Then that one, the company is saying that we didn't order it. But if the company indicates that they ordered the food, but then there's no valid agreement, but they ordered the food, why would Cow Bank order food from Golden Tulip? That is another business venture without intent that it will pay and pick the food up. Okay, so these things, they're all a matter of facts. So the facts would be what will prove the case. But all these questions are just to tell you that past consideration, especially when it comes to business arrangements or people who deal at arm's length, who are businesses, or when it comes to relationships that evoke a business transaction, past consideration would not be held to be unenforceable, but rather it will be enforceable. Okay, that's what this point is trying to say. I see that Daniel has indicated that please we will need the slides. Don't worry, once the class is done, I'll upload the slides. Another question from Sicho says, under necessaries of life, does the child not have a right to it? Does he or she have to work for it? No, so if your parent is giving you necessaries of life, that's fine. Okay. If your guardian, like your legal guardian, is giving you necessaries of life, that's fine. But if a third party, a third person, a store manager, an owner of a school, because one of the necessaries, you realize one of the necessaries that one thing that is defined as necessaries includes childhood training or giving a person some apprenticeship or training. They all amount to necessaries. So if a child goes to a school and goes to say that, oh, I want to enroll in this school and doesn't pay, the school can hold it against that child. But as between a parent and that child, it's the parent's job to do that. Okay, it's the parent's job to do that. If it's their legal guardian, it is the legal guardian's job to do that. Okay, it's the legal guardian's job to do that. But any other person that provides the child with necessaries of life, which the child goes to contract for, then that necessaries of life can be enforced against the child. The request for the necessaries can be enforced against the child. Then the child would have to pay for it. Okay, so please, that is it. When we get there, you would understand it better. When you get there, you understand it better. So other exceptions to the past consideration rule include past consideration is sufficient to create a liability on a bill of exchange. A claim is enforceable at law where there is a written acknowledgement of a creditor's claim by a debtor after the statute barred period has elapsed. So all this is saying is that, so in law, there's something called statute of limitations, okay? There's a limitation up as to when you can bring a case in court. So when it comes to issues of debt, loan, the period is 6 years. So if you, Sitio took a loan from me 6 years ago, I'm a bank, Sitio took a loan from me 6 years ago, and Sitio doesn't pay for the loan. He doesn't pay for the loan, and then the loan matures. And then I don't go to Sitio to ask him why he hasn't paid. I don't do a demand letter to him. I don't sue him in court. And 6 years passes. After the 6 years, I cannot chase him again. And you see, in this case, to pass consideration applies because I can't chase him again. But if Sitio writes me a letter after the 6 years that, oh, madam, I owe you money. I know I owe you money. Then the statute barred period, even though it has elapsed, the debt still becomes enforceable. So the debt is past and gone. But because of that future acknowledgement, okay, that future acknowledgement that I owe, it brings the debt back onto the table. Then finally, in a request made for service, if it is implied that there's a promise to pay for the service. So a typical example is the golden tulip and cow bank example I used over here. So these are the exceptions to the past consideration rule. I know it's been a lot that we've looked at, but these are the things that would have really confused you, okay? We are done with past consideration. When we meet next Thursday, we'll start from other rules on consideration. So we'll look at other rules on consideration. We'll look at the reforms that Contract Act has made to the rules on consideration, the common law rules on consideration, and then we'll look at the doctrine of estoppel. Then from there, we'll start with capacity to create legal relations. That's when we look at this whole conversation around children and contracts. And then finally, then we'd also look at intention to create. Okay, so next Thursday, we'll try and bring an end to contract 1. Next Thursday, we'll try and bring an end to contract 1. But then we'll meet on Saturday as well to start with contract 2. Okay, I want us to catch up. When we get up to a point that we don't need to meet on Saturday anymore, I'll let you know. For now, we do need to meet on Saturdays so that we can have enough time. We can finish the syllabus, okay, so that we can finish the syllabus. That's what's most important, to take you through each and everything. Then I know that once we're writing our exams, I've done what I'm supposed to do. Please, if you have any question on everything that we've treated today, you can ask and I would answer. So you have the floor for the next 5 minutes. Then we close. If you don't ask a question, me, I'll ask you questions. So. If you don't ask a question, I'll ask you questions. Deborah. Is Deborah in the class? I've used her name so many times. She can't tell me she's not in the class. Deborah.
Madam, please, I'm in class.
Okay. Please, what is acceptance?
Please, acceptance is when I agree to your offer.
When you agree to do what?
When I agree to your offer.
What is the difference between an acceptance and a counter offer? I need you to use some words. That's why I'm asking the follow-up question. What's the difference between an acceptance and a counter offer?
So a counter offer is when the amount of money or the what you want me to agree on is not what I want to give to you. So let's see, I agree I tell you that you should give me, you should come and work for me, and then I'll pay you this amount of money. And you tell me that you won't pay it, you don't want that amount of money, you want maybe a higher amount of money. That one is not an acceptance, but it's a counter offer.
Okay. Thank you. I think I've now satisfied myself that you understand. Okay. I used some words to get you to understand what an acceptance is. Can anybody just remember two? Just two of those words, because it's even only two I remember myself. But there's more. Daniel, do you want to help us here?
Yeah, unconditional
Excellent.
and final.
Yes.
There's another one, but I forgot it.
Unqualified and absolute. So you can also have that at the back of your mind. Unqualified and absolute.
Madam,
Okay.
a question.
Yes, please.
So I have not seen a past question yet, but I
Yes.
just want to ask this.
Okay.
With how you are teaching us,
Yes.
it is very practicable. So
Yes.
the thing is it going to be in a form of, they will give you a scenario, a case study for you to be able to know that this is what is actually happening, or is going to be in a form of, you have to define acceptance, you have to, I just want to have a knowledge about, so that if we are studying, we know how to tackle it.
Okay, so that's the thing. That's the thing with the ICA. It's not, if you're a law student, I'll tell you that, oh, just be learning these things, because nobody's going to ask you what is acceptance. In law school, nobody would ask you what is acceptance, what is offer. What they would rather ask you is, they'll create a scenario, as you said, and then they'll say, they'll give you a scenario, and then you would now have to determine whether there's an offer, whether there's an acceptance, whether there's a counter offer, those things. And then you come to the final question you would ask yourself is whether there's even a valid contract. But that's there. But the thing is, the ICA doubles in both type of question as asking of questions. They sometimes would ask you to define concepts. You understand? And at another breath, they can also ask you, they can put a scenario there, and then they'll say, they would ask you like a problem question. So they'll put a scenario and then they'll ask you to answer the question, or to determine liability, or to determine whether there's a breach or something like that. So I wouldn't say that there's one way that they can ask their question. Sometimes they can ask it as plain as, what is this? And in another vein, they would even quote like they would put together facts from a case and then ask you which of them is liable or something like that. I've seen a couple of questions like that. So not for contracts per se, but for other topics. Okay. So that's why I try my possible best that in everything that I'm teaching you, I try to have it as practical as possible, so that if it comes as a question, what is acceptance, you can write. If it comes as it is a problem question, this person bought a car from this person. This person promised to pay or came back and said, oh, the car that you are selling for 3,000, I will want to buy it, but I'll buy it at 2,500. And then then Kofi went ahead and sold the car to another person. So let me give you a scenario, and let me just say it this way. Kofi made an offer, or Kofi decided to sell his car. He went to his friend Kwabna. He told Kwabna that the car is 50,000. Kwabna told Kwabna that if he accepts to buy it, he should let him know. Kwabna comes to him and tells him that I'll buy the car. I want to buy the car, but I'll buy it for 30,000 instead. Kofi didn't call Kwabna again, and then he went to call his friend Amma and told Amma he's selling the car, and Amma decided to buy the car for 50,000. And then Kwabna came back and wanted to buy the car for 50,000. And then I think I've seen a question like that. Now that I'm saying it, I think I've seen a question like that. And then Kwabna came and said, I would buy the car for 50,000. Now, you now buy the car for 50,000. By the time he came, Amma had already bought the car. And then Kwabna got upset and went to court and sued his friend, Kofi. Then they'll ask you, do you think is Kofi liable? Okay, is Kofi or has Kofi breached the contract? Clearly, this question is about the difference between offer and acceptance. No, acceptance and counter offers, and then the effect of counter offers. Because obviously, Kofi, once he gave the car, he decided to sell the car to Kwabna at 50,000. And then Kwabna said he would buy it at 30,000. That amounted to a counter offer. And a counter offer, an effect of a counter offer is that you have rejected the offer, meaning that that offer is no longer on the table. So if at a later date you even come back and say, I'm accepting it, it is not there anymore. Okay. So Kofi can go ahead and sell the car to Ama, and he has not breached anything. So that's the way you answer it. But in answering it, you realize you talk about counter offer, you talk about acceptance. Okay, you may define them and talk about them. I'll show you how to answer problem questions. That one will be when we are getting closer to the end of our discussions, like when we are getting closer to the exams. There's a way you answer problem questions that is very easy. Okay, so we'll do that. But these type of questions too come. Okay, so I try that in teaching you, I give you everything so that when you go, you are sorted. Please, Daniel, I hope you understand what I'm saying. Because your people, sometimes they'll say, what is? Another time they'll say, who is liable? Or who is this? You get me?
Okay. Okay. Thank you, madam.
You're welcome.